Okay, thanks. So, good evening, everyone, and hello, Clinton, and welcome as well to the other show.
Please call me Karina.
Oh, Karina, sorry. Okay.
That's okay. Sorry.
Why was that? Oh,
I'm so glad that I'm able to join in today because I haven't been able to. I work full time and I've got 4 children.
Oh,
So
okay.
6 to 7 o'clock is the busiest time for me to look after kids and settle them and everything. So I'm so happy that I'm actually can be here today.
I understand how busy it can be, Karina, because I've got 5 kids of my own.
Oh, I have 1 less.
Okay, so has the recording started? Okay, it has. So welcome everyone. And so we've got Karina and Clinton joining tonight's session. And welcome to those who will be viewing this recording. So tonight we will cover the topic on unauthorized decision making. And it's also a very important topic because we often wonder, because remember, we're talking about the executive. And what we often have to ask is, does the executive have the authority to do whatever it wants? Does it require any specific authority from the Constitution or perhaps from the Parliament in order for the executive to do certain things? Or would it only be in certain circumstances that the executive is actually required to be able to point to a specific, say, parliamentary authorization in order for it to act? And so, for example, would the Prime Minister or the Cabinet have the power to create another agency? And that agency, for example, might be tasked with the purpose of examining the necessity of universities undertaking, student evaluation surveys. So the question is, would the executive, for example, have the power to actually just create an agency on its own without getting an authorization from Parliament? Or would you need a statute or a law from Parliament in order for the executive to do that? Or the question might be that whether or not, in relation, for example, to the boat refugees, would the Minister for Home Affairs, who used to be the Minister for Border Protection and Immigration, actually have the power to stop the boats, the boats containing refugees from entering Australian territory, assuming that it is not under the it's not under the Migration Act of 1967. So what if the Migration Act of 1967 does not provide any express or implied authority to the Minister for Border Protection to actually turn back boat refugees? And for the minister, for example, to be able to have the power to authorize the Australian Navy to pull these boats into international waters. So what if the Migration Act is silent on that? Does it mean that that act on the part of the executive would be unlawful and would not have any legal authority to be done? And let's assume that there is in fact a law such as the Migration Act of 1967, which authorizes the minister, for example, to have the power to determine who should be deported and who shouldn't be. And in relation to the specific power, for example, the Minister for Immigration and Border Protection, who is now the Minister for Home Affairs, feels that he is in fact empowered to incarcerate, to arrest and incarcerate who he thinks is an undesirable alien or somebody who has overstayed his visa, incarcerate him in one of the detention centers and leave him there for about a year. Would that be legal? And even if there were parliamentary authority to do that, can that actually be done? And so what we're trying to do tonight is actually to talk about unauthorized decision making and look more closely at the principle of legality and what exactly does the principle of legality mean. So that's what we are going to do tonight. And so after studying this topic, you should be able to discuss and explain whether legal authority is required for every executive decision or action to be made. We're also looking at unauthorized decision making and the types of executive decisions and actions that do not require specific legal authority. And so in a short while, we will begin to we will try to cover 5 tutorial problems for tonight. And what I'd like to highlight is, because we're moving towards the midterm assessment, and in relation to the midterm assessment, what it involves should be for students to answer 3 case-type problems, and their answers must be according to the IRAC format, meaning, identifying the legal issue involved, articulating the rules that inform on the legal issue, and then applying the rules to the facts, and then coming up with a conclusion based on the application of the rules to the facts. So that's the IRAC format. So what we're going to do is we will try to answer the tutorial problems tonight, also following the IRAC format, just for you to get a sense of how the IRAC format is done. I understand that a lot of you, would probably have been able to go through this because you're now in year 2, but we'll probably try to do it for just a few of for some of the problems, just for you to again have a chance at practicing the process of providing answers to case-type problems using the IRAC format. And then we should also, before we start talking about the tutorial problems, we will also try to go through quiz number 4, the question for quiz number 4. Not so much for me to provide answers to it, but just to highlight some of the key concepts, which we will cover in tonight's quiz, so that when you do the actual quiz, you're likely to be able to get the answer correctly. Now, the one thing I'd like to point out, and it's probably more of an advice, because I've noticed a number of students answering the weekly quiz straight away, such as on a Monday. So I opened the quiz for quiz 4 today, and there would be a number of students who end up answering them straight away. And my only concern is that it may be that some of these students may actually have failed to kind of, spend more time going through the study guides or the lecture podcasts that I prepared, and they would have lacked the benefit of the tutorials we have where I actually go through the quiz. So I think it will actually be to the benefit of students. So just kind of delay answering the quiz for the week, because they actually have 7 days to do it anyway. So even if I open the quiz today, you actually have until Monday of next week at 11 o'clock Queensland time to actually answer the quiz. And so especially if you take the trouble of listening to the tutorial tonight, then you have a much higher chance of getting the answer correctly. And what I need to point out is that it's not that when I provide the possible answers to the quiz, it's not so much about these being trick questions. It's really about providing concepts just to find out, to test if you've actually been able to have a proper understanding of what those concepts represent. Okay, now, before I start talking about the quiz, and just to highlight some of the key points, Clinton has a question which I'd like him to raise at this point, because I think it's always important for some of these questions to be clarified, because they often are opportunities for concepts to be elucidated. So Clinton, do you mind, if it's all right, can you just ask the question?
Yeah, hello. It's probably not exactly on point, but last week you were talking about like New Zealand citizens who were in jail for a year or something, and the minister's decided that he's got the right to send them home.
Mm.
If they go for a judicial decision, like, do they get to stay here while that decision's made? If they go for, or do they get sent back and then they have to apply for a decision or review? Do they get a judicial review here, or?
Very good. That's a very good question. So let's try to provide some, from some factual context. So in the example of Clinton, and that's a very relevant point, and this is actually factual in the sense that it is something that's quite discussed often, both by the Prime Minister of Australia as well as the Prime Minister of New Zealand, because I think a month ago, the current Prime Minister of New Zealand, Jacinta, is that correct? Jacinta Ardern, complained that, Australia, with whom it's always had very strong ties, was becoming a bit stringent in relation to some New Zealand citizens and, kind of kicking them out of Australia. in relation especially to what might be deemed by Australia to be undesirable aliens. So the question that Clinton had was, what if you have a situation where there is a New Zealand citizen, and it's not just about a New Zealand citizen, we're actually talking about citizens of other countries in general who may actually have a permanent resident in Australia, but they do not have any, but they're not Australian citizens. And under the Migration Act of 1967 Commonwealth, the Minister of Immigration and Border Protection, who now is the Minister for Home Affairs, has the statutory authority or the power to cause the deportation or the exclusion or their exclusion from Australian territory of those individuals who are deemed undesirable, or those who have been convicted and subjected to penalized by sentences involving imprisonment of at least 12 months. So the cutoff point there is that you have an individual who is not an Australian citizen, who might be an Australian permanent resident, but who has committed a crime and has been convicted and he has been sentenced, which involves imprisonment of at least 12 months. So under the Migration Act of 1967 Commonwealth, the Minister for Immigration, or now the Minister for Home Affairs, has the power to exclude that alien, or meaning to deport that alien from Australia. The question of Clinton was, can he seek judicial review? And if he can, does it mean that on the basis of the judicial review proceeding, then that person can stay in Australia? So the first question that needs to be answered is judicial review available? And so what we need to remember is that when it comes to the power of judicial review, and we're talking about the federal court system here, when an executive decision is based on an enactment, meaning it's based on a statute or a law passed by the Commonwealth Parliament, or it could be that an executive decision is based on an instrument, such as a bylaw or a rule or regulation passed by the executive as a result of a statute authorizing the executive to do so, coming from the Parliament. So in other words, on the basis of subordinate legislation. So there's an enactment. In that particular case, on the basis of the existence of an enactment, then judicial review is available under the Administrative Decisions Judicial Review Act of 1977 Commonwealth. So it is available. Now, on the other hand, if the decision, for example, was not based on an enactment, and the example I gave was that instance of the minister turning back boat refugees from entering into Australia, there is actually no authority coming from the Migration Act of 1967 Commonwealth authorizing the minister to turn back the boats. So it's not under the Migration Act of 1967. So the question is, does the minister have the authority for that? And should I answer that now? And the answer is, while in that particular instance, for example, while there is no authority on the basis of a statutory enactment, we do know that there is such a thing as the inherent powers of the executive. The inherent powers of the executive means, these are oftentimes called the prerogative powers. So the power of the executive, for example, to enter into contracts, the power to enter into treaties, the power to the power of the executive to pardon prisoners. These are known as prerogative powers, or the inherent powers of the executive, even in the absence of statutory authority from the Parliament. And apart from statutory authorization, meaning authorization coming from the Parliament, and apart from the prerogative powers of the executive, the other source of power of the executive is actually Section 61 of the Australian Commonwealth Constitution, which under Section 61, the executive has the power to execute the laws of the country. So those are three sources of the powers of the executive. So having said that, let me just go back to the question of Clinton then. So in the instance of the exclusion of New Zealand undesirable aliens, for example, and having them deported from Australia, there would have been a ground to apply for judicial review under the Administrative Decisions Judicial Review Act of 1977 Commonwealth, because the executive decision would have been based on an enactment. But the other question was, would it mean that there will be a stay of the decision to exclude the alien if a person has applied for judicial review under the ADJR Act. That's the question there. Now, there are two answers. There are two possible answers to that question. The first possibility is, yes, it's possible that the proceedings to deport a person may be stayed if authorized by the Migration Act of 1967 Commonwealth. And for our purpose, we don't have to look into the specific provisions of the law because we're not studying the Migration Act of 1967 Commonwealth. So the first answer is, if the Migration Act of 1967 Commonwealth provides that in the event that a person applies for judicial review of a decision seeking a deportation of a person, then there should be a stay of proceedings. Then in that case, that is the answer. And I don't have the answer for that because we're not studying, as I said, the Migration Act of 1967 Commonwealth. The other answer is, assuming that the Migration Act of 1967 Commonwealth does not have that provision, does it mean that the courts cannot, therefore, have a stay of proceedings? And the answer is no, because the moment that the courts take cognizance of a proceeding and it is undertaking judicial review, then under the Administrative Decisions Judicial Review Act of 1977 Commonwealth, it may, for example, issue an order of prohibition or even injunction. So, and we're going to examine, judicial review remedies, I think, in week 11. And for example, when it comes to the issuance of a writ of injunction, it is within the power of the court, assuming the court has jurisdiction over an application for judicial review. It has the power to enjoin the executive, such as the minister, from enforcing its decision to exclude an undesirable alien. And it can also mean that the court may issue a writ of prohibition, again, leading to an order that the minister not continue with the deportation. And when we speak of writs of prohibition, which we examine a bit later on, it will be because there is, for example, a violation of the right to natural justice. So somebody should have been given an opportunity to be heard, and yet wasn't given an opportunity to be heard. And there was just this decision of the minister to then kick that person out of Australia. Okay, so that would be the answer, Clinton. Did that answer your question?
Yeah, that was really well done. Thank you.
Okay, thank you. The other point I actually was saying was, because I kind of forgot to follow through, was that the other example I gave was that we've heard of instances of the Minister for Border Protection, now the Minister for Home Affairs, turning back both refugees. And I said that the Minister for Immigration and Border Protection really does not have the authority under the Migration Act of 1967 Commonwealth to do that. And there is no statutory authorization, or there is no statute which actually authorizes the Minister for Immigration and Border Protection from turning back boats. So the question was, can the minister do that? And so the answer is yes, because he has the inherent power to do that, known as the inherent or prerogative powers of the executive. Now, the other question then is, but if the decision of the minister is not based on an enactment, but on the exercise of his inherent or prerogative powers, then you cannot have recourse under the Administrative Decisions Judicial Review Act of 1977 Commonwealth. Remember? Because the ADJR Act of 1977 is available only if the executive decision is based on an enactment. So if the executive decision is not based on an enactment, but based on the exercise of an inherent or prerogative power of the executive, then you cannot have recourse to judicial review under the ADJR Act of 1977 Commonwealth, because that is a jurisdictional requirement. So does it mean, therefore, that these boat refugees do not have any legal alternative or option to undertake judicial review? And the answer is no, because one, we have what is known as common law judicial review, where it is always within the power of the courts to examine the legality of the actions of the executive. So where there is a presumed breach of the law by the executive, then the courts have always exercised their common law powers to police or the exercise of executive powers. That's one. So there's the common law power of judicial review. The other thing we need to remember is that under Section 75(5) of the Australian Commonwealth Constitution, that particular provision provides that the High Court has original jurisdiction to issue the writs of mandamus, prohibition, or injunction in relation to officers of the Commonwealth. So you have the instance, therefore, of the Minister for Immigration and Border Protection, who is an officer of the Commonwealth. He can be the subject of judicial review under Section 75(5) of the Australian Commonwealth Constitution. And we also need to remember that under Section 39B of the Judiciary Act of 1903 Commonwealth, the Federal Court of Australia has the power to issue writs of mandamus, prohibition, and injunction against officers of the Commonwealth. So there is a similar provision, except that the power of the High Court is based on the Constitution, and the power of the Federal Court is based on the Judiciary Act of 1903 Commonwealth, or particularly Section 39B. So, in other words, it doesn't mean that because the executive is exercising its powers under its inherent powers, that then that power can no longer be the subject of judicial review. It can still be. It only is a question of, can you apply for judicial review under the ADGR Act, or can you do it on the basis of a common law judicial review, or perhaps on the basis of Section 75(5) of the Australian Commonwealth Constitution, or Section 39B of the Judiciary Act of 1903 Commonwealth. Okay, thank you. Now, so we could probably go to quiz number 4, and my purpose of just looking at this week's quiz is to try to just highlight to you some of the key concepts, so that as we go through some of the tutorial problems tonight, you will be in a better position to then draw a connection between the quiz and the key concepts, and the same concepts that will emerge in the course of us discussing the tutorial problems that we have. So can I ask either Karina or Clinton just to read quiz 4? We will not answer the quiz because that's part of the assessment, but all I'm going to do is to just ask some questions, just to draw your attention to what the key concepts are. So can I have somebody, either Clinton or Karina, to read the quiz 4 for us?
Okay, I'll do it.
Thank you.
Okay. Sherry Summers was suddenly awakened at a little past midnight by officers of the Australian Taxation Office, knocking on her door at home and informing her that they were seizing her computer, documents, and records in relation to the operations and activities of Summers Whiz Kids Childcare Centre, which she owned as a sole trader. The ATO officers informed her that they were acting under the authority and orders of Australian Commissioner of Taxation, who had acted upon a detailed report that she was involved in tax fraud. The ATO officers explained to Summers that the Commissioner, although he was not authorised by the Income Tax Assessment Act 1997 Commonwealth or any other statute, had inherent non-statutory executive power to issue the orders when she was reasonable cause to believe that tax fraud has been committed. Following this intrusion into her home and documents, Summers approached you, a solicitor, for advice. Do not read the Income Tax Assessment Act 1997 Commonwealth or any other statute relating to the powers of the Commissioner.
Thank you, Karina. Thank you so much. So let me just highlight a few things here. So we will notice that the power of the Commissioner, when he issued that order to his officers for the documents and computers and records of Sherry Summers to be seized, he actually issued that order on the basis of his inherent executive power. So it wasn't based on a statute. Okay? So he was exercising inherent non-statutory executive power. So that should be clear. Okay, so the question is, does the Commissioner of Taxation have the power to issue that order if he was not authorized by a statute to issue that particular order. So in other words, is the Commissioner of Taxation legally correct in asserting that he has the inherent executive power, even in the absence of a statute from the Commonwealth Parliament, to issue the orders? That is the question. Now, because remember, we will recall that the executive does have inherent executive powers. Okay, we know that. We said, you know, he can enter into a contract, he can enter into a treaty, he can pardon, you know, prisoners or commute sentences. That is an inherent power of the executive. So in this particular instance, therefore, the Commissioner of Taxation is saying, I have the inherent power as the executive to issue this particular order. I do not need an authorization from the Commonwealth Parliament. Is he legally correct? You're going to have to wonder that, right? Or what if the Commissioner of Taxation, for example, says, I have the power to cause the arrest of somebody I believe has committed the crime of tax fraud? Oh, there's a question here. Does that mean, from Corina, she has a question here. Does that mean that the officers did not have warrants to enter the property and seize the documents? So under the facts, there is no warrant coming from the courts. Okay, so this is just an action undertaken on the basis of an authority coming from the Commissioner of Taxation himself. Okay, so that should be clear. So as an example, the question I asked was, you know, what if the Commissioner of Taxation asserts that he has the power to cause the arrest of an individual who has been found by the you know, ATO investigators to have committed tax fraud? Does he actually have the power to do that? What exactly is the principle of legality? Okay, so can you remember that? So remember, this is the assertion of an inherent non-statutory executive power. So if you look at the possible answers, Corina, can you go through the possible answers for us?
I was I was just thinking, the computers and documents and records are Summer's property, and her right to, she has a right towards those properties. Okay. And if the commissioner was going to restrict or cease to approve that rights to the property, yeah, I think he should have had the statutory support. Authority. So,
go on.
Beg your pardon?
Why do you think, you know, that is the case? Why do you think he needed authorization from the Parliament if he was going to interfere with the rights of Sherry Summers? Why?
Because it's against the common law and the rights of well, it's against the common law, I think.
Yeah, so there is a common law right. You're actually correct. There is, in fact, a common law right. So I'm going to state that as a fact, or as a legal principle, that the courts recognize a common law right on the part of citizens to the right to life, liberty, or property. Okay, yes. So you can actually see that in the U.S. Constitution. No person shall be deprived of life, liberty, or property without due process of law. Of course, we don't have a Bill of Rights in the Australian Commonwealth Constitution, but our courts, or the courts of the common law countries, whether the UK, Australia, or New Zealand, recognize a common law right on the part of citizens to have their property, their freedoms not be restricted by the executive or by the government without due process of law.
Mm. So I think because the common law rights of Sherry has been violated, and therefore she should be able to apply for the judicial review on the common law judicial review, I think.
Okay, but the question for us, Corina, really is this: what is the legal position of the Commissioner of Taxation correct? He was saying that he does not have to get any authorization from the Commonwealth Parliament to seize the documents of anyone because he has the inherent power. Is that correct or not? That's really
no. I don't think it's correct.
Why is that?
Because in order to violate somebody's common law rights, he will need to have authorization, legislative authorization to take such action.
What's the principle for that? The principle of?
I knew that, but I forgot. Hang on. Oh yeah, I knew it.
Okay. Very good.
Okay, well, yeah, I can't remember.
As I said, I'm not going to provide the answer to the quiz, but I think, you know what the correct answer is. No,
entrenched minimum provision of judicial review, is it?
No, at this point, we're not really looking at judicial review per se. We're actually looking at the, one of the principles, and that's actually found in the, Clinton was saying it's the principle of legality. So the point we're trying to emphasize here is the principle of legality. What exactly is the principle of legality? Okay, so that is the answer there. What is the principle of legality? Because if you apply the principle of legality properly, then you will know whether or not the Commission of Taxation was correct. Okay, so very good. So we cannot answer that because that's quiz 4, but we did, draw attention to what the proper answer is. And I think Corina did a good job of providing an answer there, which certainly went beyond what was required by the quiz. So that was, the one provided by Corina is, the kind of answer you would give in a longer case type question. And she was certainly, on the right track. So well done. So we're gonna have to leave that because we cannot answer that quiz. It is a quiz which students have to answer this week. Okay, so let's just go through some of the discussion questions. Can I get somebody to read discussion question 1 for us?
Yeah.
Thank you, Clinton.
Judicial review is said to be of limited scope that focuses on the process of decision-making, observation on fairness, procedural fairness, and natural justice, etc., and not on the decision itself. In what circumstances is judicial review said to involve a review of the decision itself? Okay,
I mean, would anyone want to answer that? Because I wouldn't mind answering it myself, because I don't want to put, either of you on the spot so that you are forced to answer a question. But I appreciate you reading the questions. So, yes, Clinton, did you want to try to answer the question though?
Well, I think it comes down is the principle of the decision a question of legality? Is it they can review it if it's not legal or if they're checking the legalness of the decision.
Okay, I'm kind of looking at the substance of the decision. So I'm trying to connect it to the issue about merit. So, for example, we will recall that as far as review by administrative tribunals, such as the Administrative Appeals Tribunal, when they undertake merits review, they obviously look at the substance of the decision. So that means they look at the factual circumstances, and then they will decide whether or not to overturn the decision or to affirm the decision of the executive. And in general, therefore, we say that when you contrast merits review with judicial review is limited to an examination of the legality of the decision in the sense that of whether or not the decision is legal according to the law without looking at the factual circumstances of the decision. In other words, even if the executive makes a wrong decision because it misappreciated the facts, okay? So assuming there is a factual error on the part of the executive, so it could, because remember that when it comes to merits review, if there is a factual error, that factual error can lead to the AAT reversing the decision or modifying the decision. But when it comes to judicial review, because courts are limited to an examination of the legality of the decision, they do not examine the factual correctness of the decision because that is merits review. And courts do not really have the power to make decisions in behalf of the executive. So the question is, are there instances when the courts will kind of examine whether or not there is a factual correctness, whether or not the executive actually arrived at a decision that is really supported by the facts? So that's really the question. Because we said, when it comes to merits, courts, the administrative tribunals can review the factual correctness of administrative decisions, but courts cannot. So even if there is a gross factual error on the part of the executive, courts have no power to say that the decision is unlawful, simply because there is a gross factual error on the decision does not mean that the decision is unlawful or that the decision is contrary to law. So let me repeat that. The mere fact alone that an executive decision is erroneous, grossly erroneous on the basis of the facts, does not mean that the decision is unlawful. Are we clear about that? So that is general rule there. So therefore, if there has been a misappreciation of the evidence on the part of the executive, if the executive made an incorrect decision because it arrived at a wrong conclusion in relation to the facts, that even if there is a gross factual error, that gross factual error does not mean that the decision is contrary to the law. And there is no room for the judiciary to overturn that decision in general, okay? So, and I'm gonna go to that point raised by Karina and Shortwell about whether the decision is unconstitutional ultra vires. So, under what circumstances might it be said that on the basis of the facts, the courts can actually say that the decision is contrary to law? And there are at least two instances, as we see later on, when it can be said that judicial review is available to examine kind of the factual circumstances of the decision. One is when there is what is known as Wensbury unreasonableness. So when the executive arrives at a decision that on the basis of the facts, no reasonable authority could have arrived at that particular decision, then that is what is known as Wensbury unreasonableness. And when there is Wensbury unreasonableness, then the courts have the power to set aside that decision of the executive. So that's one instance. So if on the basis of the facts, so for example, when under the circumstances, say in relation to the New Zealand person who was incarcerated, and it is clear that on the basis of the facts, that person had only been imprisoned for, let's say, for 2 months. And what the executive did is to make a finding that the individual had been imprisoned for more than 1 year. But it simply is not in the facts. In that case, when you think about it, because the real factual scenario is that the person had only been imprisoned for 2 months, then there is no reasonable authority or officer could have arrived at the decision that that individual had been imprisoned for a year or more. So that would, in that case, if the executive arrived at that decision anyway, then what we have is what is known as Wensbury unreasonableness, because that executive decision was a decision that no reasonable person, was so unreasonable that no reasonable authority could ever have arrived at that decision. So that's one, Wensbury unreasonableness. The other instance is when an executive decision is when there's simply no evidence to support the decision. So when the executive, for example, says that this person had been imprisoned for 1 year, when the person had never been imprisoned, that again is an instance when the courts are actually kind of looking at the factual circumstances of the case. So as an exception to the rule that courts in general, when they undertake judicial review, they don't really look at the factual circumstances of a decision. Two of those instances would be when there is Wensbury unreasonableness in the decision of the executive, and secondly, when there's simply no evidence that supports the decision of the executive. And we're actually going to be examining this, I think, in week 7 or week 8, of our term. Questions now. Karina had a question here. When the decision is unconstitutional or ultra vires, what happens then? Okay, so let's assume that the executive makes a decision on the basis of a statute. And I think what Karina is saying is that what if, because the decision itself, oftentimes you don't really say that the decision itself is unconstitutional. Oftentimes you say that the law authorizing the decision is unconstitutional. You do say that the decision is invalid because it is against the law, okay? But we talk about constitutionality of a law. But so let's assume for the moment that there is a decision of the executive, and let's assume that the scenario I gave was that the Minister of Immigration or the Minister of Home Affairs decided to, to incarcerate or leave in a detention center, an immigration detention center, an alien who had, for example, been engaged in immigration fraud, and to order his detention for a year in an immigration detention center. And in that particular instance, we will say that there will be a violation of the common law right of the individual, possibly the violation of the common right of the individual to liberty. So in that particular circumstance, can the individual go to the court to question the constitutionality of the decision? The proper term that there is not the constitutionality of the decision, it's more of the legality of the decision. Okay, the point there is, it's more of a can the individual go to the courts to question the legality of the executive decision. It's not so much the constitutionality of the decision. But on the other hand, what actually happens if there is a law which authorizes the Commonwealth, which authorizes the Commissioner for Home Affairs to indefinitely detain an undesirable alien for even 1 year or 2 years. So let me repeat. What if you have a situation where there is a law passed by the Commonwealth Parliament authorizing the Minister for Home Affairs to detain an alien for a period of 1 year to 2 years if that individual or that alien has committed immigration fraud? The question is, and then the minister makes a decision. Then the minister makes a decision, detaining the person for 1 year or 2 years. What happens then? So in that case, that is a different scenario, because you're no longer testing the legality of the decision of the minister. You're actually questioning the constitutionality of the law itself. Okay? So in that case, if you're talking about questioning the constitutionality of the law itself, not the decision, but of course, by questioning the constitutionality of the law, if the law is declared unconstitutional, then by force of logic, then the executive decision will also be unlawful or illegal. So what if you somebody files an action questioning the constitutionality of the law? That is not administrative law anymore. That's actually part of constitutional law, although it does have an impact on judicial review. The key point there is that we make a distinction between constitutional law and administrative law, because if you're questioning the constitutionality of the law, there is really no reason, there's really no need for you to limit yourself to the question of judicial review. You're simply, in that particular instance, you're attacking the constitutionality of the law itself. Okay, I don't want to veer away too much because I don't want to get into constitutional law, which can be quite confusing. Okay, so in general, therefore, when it comes to administrative law, the focus of administrative law is not the legality of the constitutionality of the law passed by the Commonwealth Parliament. That is not the focus of administrative law. The focus of administrative law is really the decisions of the executive. So it is not, administrative law doesn't really look at the legality or constitutionality of the underlying statute that authorizes the actions of the executive. Administrative law focuses on the executive decision itself. Okay, so welcome, Faith. Thanks for joining us. So we could probably move on to question 2. Okay, I think we could. Yes. Can I have Clinton, Faith, or Karina to read question 2 for us?
Okay, I'll read. Okay. The Minister of Health created a health awareness program that provided a budget of $20 million for a program to promote awareness of men's depression as a health issue. Red Manson, who was a law student at one time, asserts that the program is rubbish and has called on the minister to withdraw the funding, claiming that the money is better spent on other programs in the current economic environment. He also asserts that the minister has no legal authority to make the budgetary decision. When the minister refused to revoke his decision, Manson considered filing an application for judicial review on the ground that the decision is unauthorized. He seemed to remember during his law student days that minister is required by the principle of legality to have a statutory authority from Parliament in order to create the health awareness program. Manson has come to you as a solicitor. What would you advise him?
Very good. Thank you, Karina. So I'm just going to provide the answer here. So as we said, we're going to try to practice using the IREC format in preparation for the midterm assessment as well as the final assessment. So the legal issue here is, does the minister require a statutory authority under the principle of legality for the purpose, in order to be able to create the health awareness program? So let me repeat that. Does the principle of legality require that every single action of the minister, such as creating a health awareness program and providing a budget for that, does that require an authority, a statutory authority from Parliament or not? So was that clear? Let me repeat the legal issue. The legal issue is whether or not, under the principle of legality, the decision of the executive, or in this case the minister, in order to create the health awareness program, requires a statutory authority from Parliament or not. That is the legal issue. What is the rule? So I'll answer that. So there are two key rules here that we need to remember. The first rule is that the executive, what we need to remember is that the executive has executive power under Section 61 of the Australian Commonwealth Constitution. That's one. So even in the absence of authority coming from the Parliament, the Constitution itself, which is over and above any law passed by the Commonwealth Parliament, has given power to the executive, has given the executive power. Secondly, apart from the authorization of Section 61 of the Australian Commonwealth Constitution, we do know that there are some jurisdictions, such as the UK and New Zealand, where they don't have a written constitution. What then is the basis of the powers of the executive? And the answer is, there are inherent or prerogative powers of the executive that have long been recognized by the courts, that inhere the executive. Because otherwise, how else can the government function if you don't have a constitution which recognizes executive power? So there are inherent executive powers of the executive, or what we know, or what we call prerogative powers. So that's clear. What exactly then is the principle of legality? The principle of legality states that any executive decision must be according to the law. So that's in general. Any executive decision or action must be according to the law, or be based or supported by law. So when we say supported by law or be based on law, what kind of law do we need? Do we need a statute, or is it sufficient that we assert a common law power? Now, the other part of the principle of legality really is that when the actions of the executive interfere with rights of citizens, whether that right is based on the Constitution, or it is a right based on statute, or it is a right based on the common law. Because we have certain common law rights, as we said, such as the right to life, liberty, or property. We have constitutional rights, such as the right of freedom of political communication. So the other extended point about the principle of legality is that when the executive undertakes an action that interferes with the rights of an individual, the executive must have been authorized by statute. So there must be statutory authority for the exercise by the executive of any action that interferes with the rights of individuals. So that is the principle of legality there. And you're going to have to try to connect that to the current quiz. So in other words, if the executive undertakes certain actions, such as a health awareness program, by doing the health awareness program, there is no common law right that's violated. I mean, who's going to complain? Whose right has been violated? No one. Because no one can assert that he has the right, you know, to say that there shouldn't be a health awareness program. So in those instances where the actions of the executive do not interfere with the rights of anyone, there is no requirement for a statutory authorization or a law passed by the Commonwealth Parliament. Because as we said, Section 61 of the Australian Commonwealth Constitution, as well as the common law, recognize certain inherent powers of the executive. So under the principle of legality, it is only when the actions or decisions of the executive interfere with rights of individuals will the executive require statutory authorization. Are we clear? Now, having said that, I have not stated the rule. So applying the rule to the facts, under the facts, what we have here is a situation where the minister's actions do not interfere with any rights of any individual. And because the minister's actions do not interfere with the rights of any individual, under the principle of legality, he is not required to have any statutory authority under the facts to create the health awareness program. And for the following reasons then, for the reason that under the principle of legality, the minister is not required to have statutory authority from Parliament to create the health awareness program, I would advise Manson as a solicitor that he shouldn't apply for judicial review of the minister's actions to have the health awareness program. Secondly, I would also have told him that the issue is non-justiciable. In other words, in relation to the decision of the minister to have a health awareness program, that is a political question. It is for the minister to decide where to allocate funds that he may have. It is not for the courts to look into the policy decisions of the executive, especially because whether or not the health awareness program is necessary does not involve a legal question. It is a political question. What kind of legal standard will be used by the courts, for example, to test whether or not the health awareness program is valid or not? It's simply a political question. And so therefore it is non-justiciable and not appropriate for the courts to review. And thirdly, I would have said that Manson should be advised not to seek judicial review because he doesn't have legal standing. As we will recall, for a person to apply for judicial review, that person must be able to show a right or interest that has been infringed or affected by a decision of the executive. Here, he has no legal standing. He cannot assert that any money coming from the Minister of Health must go to him personally. He can't say that because what he has, perhaps, is a right to government budgets, which is common to everybody. He doesn't have a specific right of his own. Okay, now, Corina here made a statement, approving health awareness program seems to be within the scope of the regular functioning of the health department and is non-coercive. That's right. So Corina is actually correct there. This is the ordinary exercise of the powers of the Minister of Health to enter into a health awareness program. It doesn't have, or it doesn't require a statutory statutory authority for that. Because imagine if every single action of the minister requires parliamentary authorization. Can you imagine how the executive can function? If every single action, every single decision it has to make requires authority come from the Commonwealth Parliament? No executive can function in that case. Like, whether or not it should buy computers, whether or not it should invest in, the NBN. If you require Commonwealth parliamentary authorization for that, the executive will not be able to function efficiently or effectively. Okay, so Manson also does not have standing, as pointed out by Karina. Very good. So on the basis of this question, we were quite clear about two things. One, that in general, when the actions of the executive do not interfere with the rights of any citizen, the executive does not require statutory authorization. So under the principle of legality, it is only when the actions or decisions of the executive interfere or affect the rights of an individual or citizen is there a need for statutory authorization from Parliament. So you have you have an answer to the current quiz on the basis of this discussion question. Okay, can we just go through quiz 3 and there would have been questions. I don't think we'll be able to go through question 4. I'm gonna post the answer anyway in Moodle. Can I just get somebody to read question 3 for us?
I can read it if you like.
Thank you, Faith. Go ahead.
Okay.
Yes.
Claiming broad powers under the Australian National Security Act Commonwealth, the Australia Security Intelligence Organisation, ASIO, Director General of Security, ordered the arrest and detention for a period of 90 days of Jameson Ibrahim, an Australian citizen who was alleged to have recently committed atrocities in Syria. Ibrahim's solicitor filed an application with the Federal Court of Australia for judicial review of the legality of his continuing detention. The ASIO Director General of Security asserts that the detention is legal since it is authorised by the Australian National Security Act Commonwealth, which provides that the ASIO Director General of Security may cause the arrest and detention for a period not exceeding 120 days of any person who he considers on proper evaluation to be a threat to national security. Advise on the validity of the ASIO Director General of Security's argument.
Okay. Do we have anyone who would like to attempt an answer to this question? This question is a bit complex because the actions of the ASIO Director General are actually authorized by a statute. Okay, so yes, Clinton.
Does it come down to that he's been alleged and he was supposed to have like a proper evaluation?
Let's assume that Ibrahim is in fact, that there is more than sufficient. There's a preponderance of evidence that Ibrahim seems to really have committed. What did he do there? Certain acts that authorizes the ASIO Director General to really cause his imprisonment. So let's assume that there is no question that Ibrahim has committed atrocities in Syria. Let's assume that it is unquestionable. It's beyond doubt that Ibrahim has committed atrocities in Syria. The legal issue really is, so in this particular case, let me just articulate the legal issue as I would see it. The legal issue is the decision of the ASIO Director General, which involves detaining Ibrahim for a period of 90 days, legal on the ground that his decision is authorized by an enactment coming from the Commonwealth Parliament. So in other words, does the fact that there is a statute authorizing the actions of the ASIO Director General, does that fact mean that the actions of the Director General would be legal in all events, in all circumstances? So in other words, it's beyond the courts, therefore, to undertake judicial review because there is in fact a statute that authorizes the actions of the executive. So let me simplify that. I think that was the proper simplification there. Is it beyond the power of judicial review when there is an executive decision that is in fact authorized by a Commonwealth Parliament? Okay, so when an executive decision is authorized by a law or a statute of the Commonwealth Parliament, does it mean that judicial review is no longer available? And which means that the executive decision cannot in all events be questioned as to its validity. That is the legal issue.
May I speak?
Yes, Corina, go ahead.
Yes, sorry. I'm just a bit confused because the power may have been authorized by the legislation. However, I think the center of the issue will come down to the proper evaluation and then the threat to the national security. Okay. If they, without properly qualifying those conditions and they exercise the power, I think that could be a problem too.
Okay. So what do you think is is what advice would you give Ibrahim in relation to whether or not the actions of the ASIO Director General were valid? Are the actions of the ASIO Director General valid because it is authorized by a Commonwealth Parliament? Or can his actions be invalid despite the authorization coming from a statute passed by the Commonwealth Parliament?
It really depends on the intention of the Parliament, though. When the Parliament made their law, enacted their law.
Mm-hmm. Let's assume that the Commonwealth Parliament expressly provided that it is within the power. Okay, Faith has to go. Good night. Thanks, Faith. So let's just assume that the Commonwealth Parliament was quite clear in expressing that the ASIO Director General has the power to detain anyone for 90 days or more when there is really evidence of the commission of atrocities which violates laws in Australia. So let's assume that that's really clear. Would it mean that the decisions of the ASIO Director General are therefore valid in all circumstances because of the authorization coming from a statute?
No, I don't think it's in all circumstances.
Okay.
Only if it is properly qualifies the requirement that it's about the security, national, the nation's security.
Let's assume that it is according the actions are according to the statute, and let's assume that it is really for the purpose of national security. In other words, the point there is, if Parliament gives blanket authorization to the Commonwealth, to the executive to do certain things, let me repeat, assuming that the Commonwealth Parliament provides some kind of blanket authorization to the executive to do certain things, such as to shoot people on sight, shoot to kill, such as the James Bond movies. Does it mean that the actions of the executive then are valid in all circumstances, assuming the executive actually complies with the authorization coming from the Parliament? If there is such a blanket authorization.
I think the legality, it is legal.
Okay. So this is a crucial point we need to remember. And this is the case of A versus Hayden number 2. So the case of A versus Hayden number 2, 1984, which is in the study guide. The crucial point is that even the Commonwealth Parliament, and of course the executive, both of them are subject to the Australian Commonwealth Constitution. Okay? So they are subject to the Australian Commonwealth Constitution. Are we clear? So the Commonwealth Parliament cannot authorize the violation of the Constitution. So any law that the Commonwealth Parliament passes that violates the Constitution would be declared unconstitutional and therefore invalid. Now, if you look, and this is partly constitutional law, when we look at the framework of constitutionalism in Australia, we have a separation of powers. So we have the executive, the judiciary, and the Parliament. The power of imprisonment, curial imprisonment, the power to detain persons, order the detention of persons, or sentence individuals, that is a power long recognized to belong to the courts. So the power to punish people for violating laws of the nation belong to the courts, not to the Commonwealth Parliament. So therefore, the courts in the case of A versus Hayden number 2 say that it would therefore be unlawful for the Commonwealth Parliament to pass a law that authorizes the violation of the Constitution, because the Commonwealth Parliament has no power to authorize anyone to violate the Constitution. And because the law passed by the Commonwealth Parliament under the facts involves the violation of the Constitution, because it grants to the executive the power to detain individuals, a power that belongs to the courts, that would be invalid. So the actions of the executive, therefore, would be invalid because the law itself is unconstitutional. Although in a course of judicial review, the issue of constitutionality doesn't really have to be raised. It's simply a question of the assertion that the Commonwealth Parliament cannot authorize the violation of the Constitution. So the answer, as pointed out by Karina, is that the actions of the ASIO Director General are invalid because the executive has no authority to cause the detention of anyone for a period of beyond 120 days, even if he were so authorized by the Commonwealth Parliament, simply because the Commonwealth Parliament has no authority to cause the violation of the Constitution. Okay, 7:04. Any questions before we end tonight's session? Very good, very clear. Okay, so thank you and good night, Clinton and Karina, for joining tonight's session. And
thank you.
remember, next week we don't have any session because
Okay.
it's the midterm break. Okay, thank you so much for joining and see you soon.
It's been so interesting. Thank you so much.
Okay,
Have a
thank
good
you,
night.
Karina. Thanks for joining. Thanks, Clinton. Bye.
Bye.
Bye.